Ready. In this case also, the manner in which the verification has been recorded of the statements made by these three witnesses for the purpose of section 9 within bracket 2 shows that the same has been done only as an empty formality, inasmuch as the same witnesses had been called before the detaining authority, and the detaining authority had recorded that whatever the statements made by the witnesses were correct. Thus, the whole exercise appears to have been done as a mechanical exercise, and it is not borne out that there is an active application of mind on this aspect of the matter by the detaining authority for the purpose of verification of the facts as had been disclosed by the witnesses, so as to express the fear and to invoke the privilege under section 9 within bracket 2 against the disclosure of the names and addresses of the witnesses, and it thus appears on the basis of the ratio of the decision of the division bench that it is a case of wrong exercise of power under section 9 within bracket 2, and it is established that in such cases the wrong exercise of power under section 9 within bracket 2 adversely affects the detainee's right of making an effective representation guaranteed under Article 22 within bracket 5 of the Constitution of India. This court quite appreciates in such cases the predicament or the dilemma of the detaining authority, inasmuch as when the action is taken promptly, it is argued that the action has been taken in a hot haste, and if the same is taken after lapse of some time, it is said that the action is delayed, and therefore the same stands vitiated. Stop para. In order to combat this argument, the division bench has rightly observed that a balance has to be struck in such cases between the public interest and the right of the detainee to make an effective representation. The detaining authority is therefore required to act in such a manner that this balance is maintained. Once the materials are placed before the detaining authority with the proposal by the sponsoring authority, it must have reasonably sufficient time for the purpose of verification of the facts and consideration of the entire material with an active application of mind, and the order has to be passed at the earliest opportunity, but in this process to strike the balance between the public interest and the right of the detainee, either of the two should not be defeated in any manner, and the whole process must indicate that the detaining authority had applied its mind with the requisite approach, and it had also devoted sufficient time before arriving at the decision to claim the privilege under section 9 within bracket 2 of the act, and also to come to the conclusion that the detainee was required to be detained immediately. Stop. In the facts of the present case, I find that this requirement of maintaining the balance has been defeated, and the detention has been passed on 30th August 1999. Stop.